Former President Donald Trump has just racked up two major legal wins, not on the merits of the case, but apparently on the timing. On Tuesday, it was widely reported that Judge Aileen Cannon had indefinitely postponed Trump's criminal trial on charges of retaining classified national security documents after leaving the White House. The trial, originally set for May 20th, has been delayed due to unresolved pretrial issues. Those unresolved pretrial issues are the fault of Judge Cannon because she is the one who has left them unresolved. Now, in 2022, in a move highly criticized by legal experts as an extraordinary overreach by a federal district judge, Cannon had accepted Trump's bid for a special master to review evidence seized by the FBI and had blocked federal prosecutors from reviewing those materials. A federal appeals court ultimately halted that special master appointment, but that caused a delay in the case. Cannon had also requested in March the prosecution and defense submit two versions of potential jury instructions for the trial. One version would ask jurors to determine whether each record retained by Trump could be categorized as personal or presidential under the Presidential Records Act. In this scenario, jurors could find some documents were mishandled per CBS News. The other would ask jurors to assume that Trump has complete authority to take the records he wanted from the White House under the PRA. Special counsel Jack Smith had filed in response to that both scenarios rest on an unstated and fundamentally flawed legal premise. Smith's team writes, the PRA's distinction between personal and presidential records determines whether a former president can possess highly classified documents and store them in an unsecure facility. Jury instructions based on this premise would distort the trial in which the PRA should play no role at all. Legal experts have weighed in on this, so that's just a couple of the issues here. And of course, every challenge that Trump makes and Cannon approves costs time. Now, legal experts have weighed in on this, saying that the case should be over already. That's Jeffrey Schwartz, a professor at Cooley Law School and former judge in Florida. There was nothing in this case that complex. Should have been over. Former federal prosecutor Neama Rahmani says Judge Cannon is a bad judge and has made bad rulings and has favored Trump at every possible turn. Every frivolous argument that Trump has raised, Cannon has entertained, going back to the search warrants that were executed at Mar-a-Lago. And once again, every time she looks into this spurious claim, it costs time. And so that's a big problem. Of course, a lot of people, we all know the reason that it's to delay. In fact, here's former White House attorney Ty Cobb.
All she's really done today, though, is make official what everybody, including Jack Smith, already knew, which was she had no intention of getting this case to trial, and she wasn't competent to get this case to trial. You know, this is something that I think it was always her objective, frankly, to prevent this from going to trial. But also, I think her inability, wholesale inability, to do it was made palpable. I do think, she is not capable of ruling intelligently or fairly on most of the motions that will be pending, and certainly the classified information issues. And I think at some point she will be removed in advance of trial. But keep in mind, this case now can't go to trial until mid to late 2025, and it won't go to trial if Trump is elected.
And there it is, really. That's the whole ball game. If Donald Trump is elected, the trial disappears. That's the whole point. That's a huge win for Donald Trump and exactly what he wanted, because there is no literal recourse. This happens, well, I mean, it already has. I mean, the trial's not going to happen until 2025. It's over. It's over. It's very, very unlikely that after this coming election that there will even be a trial. So it's done. Now, the second piece of good news for Trump and bad news for everyone else is that an appeals court in Georgia agreed Wednesday to consider Donald Trump's appeal of the disqualification matter related to Fulton County District Attorney Fani Willis and attorney Nathan Wade, which, once again, delay. That's a delay. Judge Scott McAfee, who was overseeing the case in Fulton County, had agreed that Willis could remain in the prosecution in February so long as Wade, who was in a romantic relationship with Willis, stepped down from the Trump case. Allowing Trump's appeal delays the RICO case from being heard. Now, look, it's a state case, so if he becomes president, he can't shut it down. At the same time, by the election, it'll be too late. So that's two more Trump trials that are not going to happen before the 2024 election. The third, which is the January 6th election interference case, is currently being held up by the Supreme Court, which is massively conservative. 3 of the justices were appointed by Donald Trump. So they're going to decide if Trump has absolute immunity from prosecution. Now, they don't have to rule in his favor in order to help him. All they had to do was exactly what they're doing. Delay the case. Oral arguments began before the Supreme Court on April 25th, and it looks like Trump will win a partial victory from the court on this claim. But more importantly, a trial over Trump's involvement on January 6th is now unlikely to happen before the November election. So that's it. That's 3 cases gone. No trial before the election. And again, if Trump wins, 2 of those are gone. Only the state case will remain. So now, the Stormy Daniels election interference case, that's the only case that is being held before the election and will be adjudicated before the election before the election. Okay? And, well, you might think, well, that's still going to have an impact on voters, right? I mean, you're not going to want to vote for a felon, right? You would be wrong. According to polling, a conviction would make no difference with the majority of voters. Yes, a conviction in this case. So this is an election interference case. Doesn't matter. Quinnipiac University poll in March found that 55% of registered voters said a conviction in this case makes no difference in how they would vote in the presidential race. Only 29% said they'd be less likely to support Trump. But the caveat to that is that's mainly among people who weren't going to vote for him anyway. Among Republicans, no difference. Like 9%. Okay. So understand that if this was a way to prevent Trump from getting elected, well, then it would fail. Now, I know that that's not the case. But still, at the same time, if you were one of the people that were hoping that the justice system was going to come save you from Donald Trump, well, you're going to be
disappointed!
To say that. What it's going to come down to is the votes. That's it. To turn out. And at this point in time, with everything that's going on in Middle East, Israel assaulting Rafah, ethnic cleansing, Biden's poll numbers being down, well, let's just say that on democracy being saved through democracy, I'm a little concerned. And I think you all should be